Defending larceny. From a retailer and some of the consequences in Tulsa. Defending larceny from a retailer can be difficult, but not impossible. Many people facing these charges have never been arrested before and are shocked to discover that a simple shoplifting allegation can carry serious criminal and personal consequences. While some retail theft cases involve misunderstandings or mistakes, Oklahoma prosecutors take these offenses seriously and frequently pursue convictions. If you have been charged with larceny from a retailer in Tulsa, understanding the available defenses and the potential consequences of a conviction can help you make informed decisions about your case. What is larceny? From a retailer. Larceny from a retailer is Oklahoma's shoplifting statute. The crime generally involves taking merchandise from a retail establishment without paying for it or attempting to deprive the retailer of the value of its merchandise. The allegations may involve claims that a person concealed merchandise, left the store without paying, altered price tags, switched packaging, failed to scan items at self-checkout, and assisted another person in committing retail theft. In many cases, loss prevention officers, store security personnel, surveillance cameras, and witness statements form the foundation of the prosecution's evidence. The state must prove intent. One of the most important elements in any larceny from a retailer case is intent. Prosecutors generally must prove that the accused intended to unlawfully take or deprive the retailer of the merchandise. Simply possessing unpaid merchandise is not always enough. In some situations, customers become distracted, forget an item in a shopping cart, mistakenly believe an item has been paid for, or make errors while using self-checkout systems. When intent is lacking, the prosecution may have difficulty proving the case beyond a reasonable doubt. Mistaken identity can occur. Retail theft investigations often rely heavily on surveillance footage and witness observations. While modern security systems have improved significantly, mistakes still happen. In some cases, video footage may be unclear, witnesses may misidentify individuals, or store employees may incorrectly assume someone committed a theft based upon incomplete information. Where identification is questionable, the defense may challenge whether the prosecution can prove the accused was actually the person involved. Challenging the evidence. Many larceny from a retailer cases depend upon surveillance footage, inventory records, receipts, and witness testimony. A careful review of the evidence sometimes reveals weaknesses in the prosecution's case. Issues that may arise include incomplete video footage, missing evidence, inaccurate inventory records, contradictory witness statements, and improper assumptions by store personnel. The prosecution bears the burden of proving every element of the offense. Weaknesses in the evidence may create reasonable doubt. Illegal searches and detentions. Retail theft cases occasionally involve questions regarding how evidence was obtained. Depending on the circumstances, issues may arise concerning searches, seizures, detentions, and statements made to law enforcement. When constitutional rights are violated, certain evidence may be challenged or excluded from consideration. Because these issues are highly fact-specific, a detailed review of the circumstances surrounding the detention and investigation is often necessary. First-time offenders may have additional options. Many individuals charged with retail theft have no prior criminal history. Depending on the facts of the case, alternative resolutions may be available. In some situations, a defendant may qualify for deferred sentencing, diversion programs, reduced charges, and alternative sentencing arrangements. These options can sometimes help individuals avoid the long-term consequences associated with a conviction. The availability of such programs depends upon the facts of the case, criminal history, and prosecutorial discretion. Consequences of a conviction. Many people focus only on the possibility of jail time and overlook the collateral consequences that often accompany a theft conviction. A conviction for larceny from a retailer can affect employment opportunities, professional licensing applications, housing applications, educational opportunities, scholarships, security clearances, and professional reputation. Because theft offenses involve allegations of dishonesty, employers frequently view them differently than many other criminal offenses. Even a misdemeanor conviction can create obstacles for years after the case concludes. Retailers may pursue civil claims. Some individuals are surprised to learn that criminal charges are not always the only consequence of an alleged shoplifting incident. Certain retailers may pursue civil recovery claims seeking monetary damages arising from the incident. These civil demands are separate from the criminal case and may create additional legal issues that require attention. As a result, resolving the criminal matter does not always end the entire dispute. Early action often produces better results. One of the biggest mistakes people make after being charged is assuming the case is too minor to require legal assistance. In reality, early intervention often creates opportunities to preserve evidence, identify defenses, negotiate favorable resolutions, explore diversion opportunities, and protect future expungement eligibility. The earlier a defense strategy is developed, the more options may be available. Tulsa criminal defense attorneys. Larceny from a retailer charges can have consequences that extend far beyond the courtroom. A conviction may affect employment, education, housing, professional opportunities, and future interactions with the criminal justice system. Because every case presents unique facts and potential defenses, individuals charged with larceny from a retailer should consult with an experienced criminal defense attorney as soon as possible. If you are facing charges, contact the Tulsa criminal defense lawyers at Kania Law Office by calling us at 918-743-2233 or ask a question online.